Good afternoon, ladies and gentlemen, and welcome to another Vincent's webinar. My name is Damien Davis. I'm a Senior Manager for our Insolvency and Reconstruction team here. And this afternoon, the Insolvency and Reconstruction team would like to welcome you to another in our series of presentations on insolvency law reform. In particular, this afternoon, we shall be looking at the 2018 developments, those that are both due to come in and issues that have been flagged at the government level for further legislative works during the course of this year. I'll just leave it go for a minute to make sure that people have been able to log in, and then we'll commence the presentation. Thank you. Okay, so yes, this afternoon is we're looking at the insolvency law reforms, the 2018 developments. My name is Damien Davis. You may have seen some presentations here by me previously. I'm a Senior Manager in the Insolvency Department. I've been working in insolvency for close on 20 years. I'm originally from Sydney, moved up here a number of years ago, educated at UTS. I've spent a bit of time working overseas in the UK, in the Middle East and Europe. There's all my qualification details and my very beautiful artist rendition, thank God. So this afternoon we shall be looking at the developments which are due for to either come in or be worked on by the government during the course of this year. In particular, we'll be looking at Ipso facto clauses, which obviously affect in the majority corporate proceedings. The introduction of the one-year bankruptcy rule, which obviously is a matter that affects personal. And then looking at the government's recent flagging of developments in relation to anti-phoenixing and legislation that's required around that particular matter. If there are any questions that anybody has during the course of the presentation, feel free to include them in the chat. I'll have a look at them and see what we can do. In the alternative, feel free to get in contact with me. My details will be available. Girls monitoring the matter will put my contact details in the chat. More than happy to take a phone call, have a coffee, go through any queries you may have. So just having a look at the insolvency law developments as they've occurred to date. As you may recall from the webinars delivered last year, the Insolvency Law Reform Act of 2016 came into effect last year in two tranches, the first in March and the second in September. I've done previous webinars going through the various changes and how they may affect your clients. I encourage you to have a look at the Vincent's website. If you'd like me to redress or have a look at any particular questions associated with those webinars, feel free to get in contact with me. More than happy to discuss those. There were, however, a few amendments that were still due to come in 2018 from that legislation, the most important of which being ipso facto clauses, and that's what we'll go through today. In particular, in addition, the government has also introduced the one-year bankruptcy rules. That legislation has yet to pass Parliament, but is on the legislative agenda for this year. And they've also flagged consultation papers and various ideas that they have in relation to anti-phoenix activity. As of yet, there hasn't been any legislation introduced around that, but the consultation paper was introduced in September of last year, and they've made it, well, indicated that it will be a priority for them moving forward. So ipso facto clauses. Ipso facto clauses, the legislation around this received royal assent in September of last year. The legislation that brought in this particular matter was also included in the safe harbour regime, and safe harbour has been effective and is effective from September of last year, whereas the changes to the ipso facto clauses are not due to come in until the 1st of July this year. With respect to that, just for attendees' knowledge, I am going to give a further presentation on safe harbour regime and its effects on your clients and the possibilities associated with that in approximately 2 weeks. Feel free to contact the girls here at Vincent's. They'll give you details of that particular webinar, which I believe is, about 2 weeks, so somewhere around about the 20th, 23rd of March. As I mentioned, the ipso facto clauses and the changes to those clauses became effective from the will become effective from the 1st of July of this year. In particular, an ipso facto clause occurs in contracts where it allows one party to suspend a contract on the basis of an event, or terminate a contract on the basis of an event, despite the other party either being able to continue to perform their contractual obligations or being willing to be able to perform their contractual obligations. Obviously, when I see it, the major reason for an ipso facto clause is what's known as an insolvency event, and those insolvency events are generally around the appointment of a liquidator, appointment of administrator or receiver. They may apply to not only the company that is directly involved in the contract, but also may be involved, say, if you have a group of companies, any company within a group of companies that goes into an insolvency event is enough to trigger the termination of the first contract. Sometimes the other way you would see these contracts, or these clauses drawn up in contracts, would include, say, a financial requirement that there has to be a certain assets ratio or a certain liquidity ratio involved in the contract, and if one of the parties breaches that particular ratio, then the contract's automatically terminated. As liquidators and administrators, we primarily see these sorts of clauses in construction contracts, very, very often at a contractor or a subcontractor level. But they are included in manufacturing contracts, particularly where there's a particular supply that's given. They can also appear in service contracts. There are a number of other cases where I've seen them, but generally it will occur where there's a particular service or a particular supply that occurs between two parties, and in particular where one party, the recipient of that service, is heavily dependent upon the supplier, i.e. that's the one supplier for that particular good or that particular part or that particular service. So the implication of ipso facto clauses, which have been around since as long as I've been doing insolvency, and obviously well before that, is that effectively as an administrator or a liquidator or a receiver, it becomes effectively a death sentence for the company in which you've been appointed in the majority of circumstances. You're then put in a position where you need to go back to the client or to the other contracting party and effectively talk them out of automatically instigating these particular clauses. When that happens, obviously when those clauses are implemented, then the value of a business, be it on an ongoing basis or the ability to turn around the business through trading, obviously ceases. Their major source of revenue terminates, and there's not much as a liquidator you can do about it. That's what the contract says. And then, once that obviously flows on, you've got no real chance of reinvigorating the company or restructuring it. And obviously also you severely limit the ability to recover monies in, say, a receivership sort of scenario. The new legislation is designed to try to improve the chances of liquidators in dealing with those particular matters, and also to allow receivers to look at maintaining the value of a business and then achieving a sale of that business through as a going concern, as opposed to just breaking it down into its pure assets and just selling it from that particular front. So the new legislation, it causes a stay of the contractual rights of the parties with respect to ipso facto clauses in 3 circumstances. That is the appointment of an administrator, the appointment of a receiver, or a scheme of arrangement being entered into, which is obviously the, for lack of a better phrase, non-formal methodology of turnaround and restructuring. Obviously, you'll note there that a liquidation is not one of the issues in which a stay is implemented. So if a company goes into liquidation, the ipso facto clause will still apply and will automatically trigger and obviously terminate the construction contract, as is where we usually see it, but also any other contract that such an ipso facto clause may appear in. Obviously, that's a very, the way in which that works is that obviously, in administration and receivership and a scheme of arrangement, the insolvency practitioner may be able to continue the trading of the company, whereas within a liquidation framework, really our job is not to trade the business on. There's actually limitations associated with contracts that we might be able to enter. We're only able to enter contracts within a certain month, over a certain short period of months, without the consent of the court or the creditors. The job of our liquidation is really just to wind up the assets and sell them as they are, not really to sell them as a going concern. As I mentioned previously, these sorts of clauses can apply and be triggered in relation to breaches of financial covenants. Net tangible assets and debt to equity ratios are usually the two that are around that. Basically being a very crude form of determining whether a business is solvent or insolvent. The net tangible assets being just a balance sheet test, purely assets over liabilities, and the debt to equity ratio just being a very simple cash flow test to determine a rough idea of solvency. When the legislation talks about a stay, it doesn't change the clause. The clause is still there, but the other contracting party effectively has a limitation on its ability to enforce that particular clause. That's the nature of the stay, and it provides for various different terms depending on the type of appointment that you have. Obviously, a voluntary administration, it commences when the administration starts and ends when the company is wound up. So in a voluntary administration, there are a couple of alternatives. The company can go into a deed of company arrangement, in which case you obviously you want to keep the stay there. The other side of things is the administration could end, or the administration goes into liquidation. In both cases, once that occurs, the stay is lifted and the company's or the contract can continue in terms of what its actual phrasing is, and the contract can be terminated by the other party. With respect to that, you're looking, as you would know from voluntary administration, you're looking at a period of roughly a month. That can be extended out slightly to sort of 3 months, depending on court applications. There are rare circumstances in which it may be longer than 3 months, but generally looking at somewhere between 30 and 90 days. During that period of time, the administrator will be required to meet their obligations under the particular contract. So if you, for instance, have a building company, the building would have to continue on underneath the administration. So the administrator would have to trade the business on. It's not applicable and we'll get into exactly how it's worded, but it's not applicable in circumstances where an administrator walks in on day one, stops all the building work and just says, look, I'm going to try and sell the business, but I'm not going to do any work for the next 30 days. That's not the intention of the legislation. Same applies for the receivership. It's intended for an ability where a liquidator or a receiver is able to continue the works of the business and seeks to do so over that period of time. The other alternative is under a scheme of arrangement, which, as I mentioned, is slightly less formal restructuring process. And again, in this particular case, because there's no actual formal appointment of an administrator or any particular party, it would commence on the public announcement or the scheme application being made by the distressed company and ends 3 months after that period of time, or if the company's wound up, whichever is the earlier. Again, a short window to allow a company or a party to effectively restructure its affairs and not have this particular financial, which may be a short-term financial problem, terminate their contracts and sort of limit the value of the company. The way in which the legislation is written is that it's a little bit broad. Obviously, the standard clause that we see, as I mentioned, is effectively written along the phrase of, in the event that the one or the other party enters into an insolvency event, and then an insolvency event will be defined. But there are other ways in which you can word that particular phrasing within contract law, so that you're not relying upon the words of an insolvency event. As I mentioned, looking at debt ratios and asset ratios is an easy way of doing that. The legislation basically provides a stay to any clause which has the substance of effectively terminating contract as a result of either a poor financial position of one of the parties or an event of where the company would be entering into a restructuring or a sale event that effectively, and as a result of those particular processes, the contract would be terminated. So it is defined rather broadly, and obviously that will be quite interesting, I guess, towards the latter end of this year, early next year, when these sorts of matters appear before the court, and the court's asked to define whether this particular clause falls within this definition. It'll be interesting. Obviously, there were some lawyers on participating in this webinar. I'm sure some of you have spoken internally, and I've spoken to some of my legal contacts in terms of them, looking at how they're wording their particular contracts around this particular matter, to see how they can, what wording that they put down that is going to fall within this legislation. There is, as I mentioned, in terms of just making it broad, the legislation also allows the Senate to pass regulations to expand or to address specific clauses within contracts or specific wording that may come up within contracts on an ongoing basis, so that effectively the courts, these clauses that have the intention of providing the ipso facto are covered by the legislation. So it's going to be an ongoing battle, I suspect, between the lawyers who are drafting contracts and the Parliament that's seeking to enforce their views in relation to this particular matter. A key critical factor is that the legislation doesn't prevent the termination of a construction contract or any other contract that has an ipso facto clause where that contract is terminated for other reasons, such as for non-performance or for convenience. So if you have a contract that currently has an ipso facto clause in it, the client goes into liquidation or has an insolvency event occur, and the administrator or the receiver doesn't continue to perform the works in accordance with the contract terms, they get appointed and they stop work for 10 days, 15 days while they figure out the situation. The ability to terminate the contract for non-performance is always there and isn't infringed at all. So in respect of an administration or a receivership, that particular insolvency administrator would need to be aware that they're able to continue to trade the company. They have the sufficient financial backing to do so, and that they're in a position to proceed with the ongoing works that are required for the business. So, it's not a matter of being appointed, having this contract effectively stay and sort of sit on the tools for a period of time while they figure out what the financial circumstances or try to secure a sale of the business. It's not going to work. A non-performance clause would kick in before that. The other particular matter is that the courts will have the power to override the stay. So if there's an application by a contracting party for whatever grounds to sort of say, well, look, this is not appropriate, the courts can always make the determination. They can also decrease the term of the stay so that, where it, say, an administration was to be lifted only on the winding up of the company, the courts may impose a shorter deadline on that, depending on the circumstances that are required. And that would potentially be a benefit where you've got a circumstance where, for instance, the client who is in the contract is looking to, say, provide completion to another party or whatever else, and it also will have a flow-on effect with certain elements of building contracts in particular, such as calling upon guarantees and indemnities, or contracting directly with subcontractors to get works completed on time. The ipso facto clauses and the amendments will not have a retrospective application. So in that particular set of circumstances, if you have a construction contract on foot as it is now, come 1 July 2018, that contract will still remain on foot and this legislation will not override it. It will only apply to contracts that are entered into post 2018, July of 2018. One of the issues that, speaking with my legal colleagues in respect of it, is that there is some discussion within the legal fraternity as to how existing contracts can be extended on either to next stages of projects or be redrafted in some way as to be in existence effectively now and then just continually rolled over. Really, that's going to apply to, I guess, major projects, which may be multi-stage more than sort of individual building lots. But yes, it won't be something that applies on a retrospective basis. As I mentioned, the major impact that we see as insolvency administrators, particularly in the current economy, is its impact upon builders, subcontractors, civil and major development works around the place. It will include it will affect the right of a primary contractor to take work from an insolvent counterparty, or the ability to pay or engage some subcontractors directly to complete outstanding works. It will also affect the ability of a major contractor or a client calling upon bank guarantees, cash retentions, and other securities. There is also obviously the impact of set-off claims in the event that an insolvency event is triggered. It will be interesting to see how this sort of works out in practicality, and I dare suggest I'll give a further presentation either towards the end of this year or early next year, looking at how it's actually implied, how it ties in with QBCC regulations, particularly here in Queensland, and its fallout in relation to those sorts of construction issues on an ongoing basis. So I'll make sure I put that in the diary and address that over the course of the coming year. So that deals with the ipso facto clauses. As I say, once the construction industry guys and the lawyers involved in that particular industry have an opportunity to have a look at its development and its application against existing contracts, there may be scope for me to do a further presentation on that matter towards the end of this year, in the event that it assists clients. In the event that you do have clients that fall within these sorts of contracts or have these sorts of contracts, and there are issues associated with it, feel free to give us a call. We're happy to discuss the implications of it and whether it's going to cause or provides an opportunity, I guess, for your clients. So on the personal bankruptcy front, the big development, I guess, this year is the potential for a one-year bankruptcy scheme to be introduced. As I mentioned previously, the bills associated with this particular legislation were introduced last year in October of 2017, but are yet to be passed. The government has indicated that the legislative agenda is such that they expect the legislation to be passed before June of this year. It will receive royal assent and it will become effective 6 months after royal assent, to give liquidators a period of, trustees rather, a period of time to look at their files and to see what implications result once this legislation is passed. Unlike the ipso facto clauses, this will be retroactive. So where I have a trustee position and I have a bankrupt who has been bankrupt for a period of time, more than 1 year, as at the date of this legislation, it will apply to them. So if I've got a bankrupt who's been bankrupt for 2 years, they're complied with everything, they'll be automatically discharged once this legislation comes through. And so therefore, the 6 months is to give trustees an ability to go through their files, look at their clients, and where appropriate, make objections to discharges of bankruptcy, which are going to be the only way in which to prevent the application of this law as it's currently written. The reason for preparing this law was part of the innovation reforms that were introduced by the current government, and the view from the working group was that the current personal insolvency laws were focused too much on stigmatisation and penalising failure, and so to introduce a one-year bankruptcy regime would promote entrepreneurship and innovation. Within the profession, there's a significant degree of skepticism about this. The reality is, look, a very similar regime has been active in other countries for a period of time, but there's a significant difference in that currently in Australia, depending on the year and depending on the economic cycle, somewhere between 75 and 85% of personal bankruptcies relate to consumer credit. That's the cause of what they are, people entering into these sorts of arrangements. That was less of the case in other countries where this sort of 1 year regime is the case. When it was introduced in the UK in the mid to late 90s, the numbers over there indicated that it was around about 35% of bankruptcies that actually resulted from from consumer credit arrangements, as opposed to commercial and business enterprises that people had entered into. Sure, there are people that enter into bankruptcy as a result of businesses failing and those sorts of arrangements, and those personal guarantees, etc. But the vast majority of people that we deal with, it's a commercial consumer credit arrangement, which really is in no way, shape, or form benefited or requires this particular 1 year bankruptcy. But nonetheless, they will benefit as well. So very simply, the client lodges their statement of affairs. That is the commencement of the bankruptcy, whether that's a debtor's petition or whether that's a creditor's petition. 1 year from the date of that filing, a person will be discharged unless an objection is lodged by their trustee as to their conduct or other issues. After that year, the person will be no longer required to declare that they're a bankrupt when applying for credit, require no permission to travel overseas, and will not be restricted from entering certain professions or being a company director, which currently has the Bankruptcy Act prevents, for instance, a chartered accountant or a CPA from acting as a CPA or a chartered accountant if they are bankrupt. What will happen, however, is even though the bankruptcy regime will only last for a year and a person will only officially be a bankrupt for a period of a year, they will have to make income contributions to the bankrupt trustee for the full period of the 3 years of the bankruptcy as it currently exists under the existing legislation. So you'll be bankrupt for a period of a year, you'll then go out of bankruptcy. You will still have to meet income contribution amounts for a further 2 years after that. So, if your income goes back up to 150,000, or you end your bankruptcy period and you go back into certain professions or a company director, and your income increases in accordance with that, then the trustee will be able to make recoveries from your income contributions associated with that. As I mentioned, all bankruptcies on foot at that particular date will be discharged. And again, that's a period for 6 months to have a look at it. If your trustee has objected to your discharge under 149B, then you will still continue to see out your 5 to 8 years. So effectively, as a result of this legislation, you're going to have a position where you're going to have a bankruptcy, at least a public bankruptcy, every year. You're going to be liable for income contributions for a period of 3 years, unless you commit an offence. If you commit an offence, then you may have your objection to discharge. It will run somewhere between 6 and 8 years, basically based on the current working scenarios around that. Objections to discharge will be issued in respect of books and records, failing to provide assets, income contribution amounts. To be frank with you, I think the net effect of this legislation will be that just the number of discharges going up will be significant. There are some benefits. I mean, I can see bankrupts more willing to comply. At the moment, to be frank with you, it's very often that we have bankrupts that are appointed, particularly where we're appointed pursuant to sequestration orders. We may not get a response from a bankrupt for a period of 12 months. It may take us that period of time to track them down and find out where they're actually living now, all those particular sets of arrangements, in which case we'll just object to their bankruptcies just flat out, and they'll go from 1 year to 6 years. We'll just have to do that, because otherwise we won't have an ability to conduct the investigations we need to conduct. Same position goes with the supply of books and records. If a bankrupt takes 6 months to get their documents to us, it's more likely that we as trustees will apply to object to their discharge, simply to allow us the time to conduct appropriate investigations and provide those records. So again, if you have clients that are in that set of circumstances and they wish to have a look at trying to be discharged within that period of time, then their early compliance and their early support to their trustee will greatly improve their chances of being out of bankruptcy within a year. By the same token, if you have a client at the moment who's experiencing financial difficulty and is not sure on what to do, by all means, it'd be worthwhile to talk to them on the basis that, in all likelihood, by this time next year, they'll be discharged as bankrupts. So long as obviously they comply with all the requirements. They'll still have to make income contributions, etc. But in all likelihood, from what the government has signalled, this legislation will be passed this year and will effectively receive the royal assent and effectively become effective from probably the start of next year, I'd say, on a rough time frame. So if you do have a client that is experiencing those financial difficulties, they could be discharged from bankruptcy, within the next 12 months to 18 months, as opposed to sort of having to wait out those 3 years. So the other element that has been flagged by the government is Phoenix arrangements and anti-Phoenix in matters. It's been defined effectively as a major impediment to the financial economy. And to be frank with you, it's something that's been raised by insolvency professionals for quite some years now. Having done this job for 15 years, I think my first or second appointment was a Phoenix arrangement, and not a year goes by that I don't come across 5 or 10 different Phoenixing arrangements, all of which get reported to ASIC, and frankly, very little gets done in relation to any of them. In relation to Phoenixing arrangement, part of the major issue is that what is Phoenixing and what is not a Phoenixing is not defined. But essentially, a Phoenix is a system where you would have a company, its debts would effectively exceed its assets, transfer those assets into a new entity, either via a sale contract or some other set of circumstances. Sometimes there's absolutely no sale contract, it's just transfer these assets and off we go, and put the old company into liquidation with all its creditors left behind. As I say, the government, and in particular a speech by the Honourable Kelly O'Dwyer, Minister for Revenue and Financial Services, she delivered a speech in September 2017 that identified this as a major issue that required further legislative framework and legislative remedy, which the government was to focus on during the course of 2018, following the introduction of the Insolvency Law Reforms last year. At that particular time, she issued a consultation paper called Combating Illegal Phoenixing, which had a listing of ideas that she had in relation to how they might be able to deal with this particular issue. And the government established the Interagency Phoenix Forum, and has a few different other names, but it involves the ASIC, the ATO, Fair Work Ombudsman, Department of Employment, and a few other different departments from time to time, looking at this particular project. One of the departments that was involved, for instance, was the Clean Energy Department, which looked at the installation fiasco, I guess is a best word for it, where there was a number of those sorts of companies set up to do short-term works, and then they obviously went through Phoenix arrangements. It was to a certain extent endemic in that particular arrangement. And so why has the government looked at this particular issue? Well, there's a few different reasons that insolvency administrators sort of think this has occurred, but there was a paper produced by the ATO. It wasn't released technically to the public, although some of the data was leaked. But effectively, it determined that roughly 20% of liquidations over the course of the last 5 years have involved some degree of Phoenix activity, or what the government believes to be some degree of Phoenix activity. Now, for an information, there was roughly 12,000 insolvency entities that they've identified over that period of time, that last 5 years, and the total insolvency appointments during that period of time were roughly 60,000. which gets you to your 20%. The reality is it's actually probably considerably worse than that. Of that 60,000 insolvency appointments, when you take out administrations, receiverships, and other types of appointments, the amount of companies that could fall within that phoenixing activity may rise to 30 or 40% worth of businesses. Again, that's a bit of an issue in terms of what you actually define phoenixing as, and there's some arguments between parties in relation to that. But of those 12,000 insolvency entities, there were 3,700 individuals who were identified as engaging in the activity. Now, effectively, that when you consider when they identify individuals, they also include insolvency administrators, advisors, and lawyers. Let's make a rough guess that 3,700 becomes 3,000 actual directors themselves. That effectively means that for those particular parties, each director has had 4 insolvent businesses over the course of 5 years. In particular, the ATO has obviously identified itself as the major loss maker in this particular matter. It's written off somewhere in the order of $1.8 billion worth of debt. And at the same time, the entities that have been liquidated have claimed credits in the order of $1.2 billion. So you're looking at around about $3 billion worth of loss there. And when it says falsely claimed credits, what it actually means is the party will effectively claim the GST credits, not include its liabilities, go into liquidation, have the actual accounts rectified, and that's where the discrepancy comes up. So it's a financial, it is quite a financial impact. I have seen some government papers and some press releases and discussions with the minister and other members of the parliament that have identified somewhere in the order of $3 billion per year, as opposed to $3 billion over the course of the last 5 years. I haven't seen the actual papers that have supported the $3 billion per year. I assume that includes other flow-on effects that people have made up, or politicians are just making up numbers. Not that would ever occur. So the major issues in respect of phoenixing arrangements are that they're hard to identify and separate from a standard restructuring. A standard restructuring will very often involve the valuation of the sale of the company's business and assets, and a sale to another party, be that a related party or a completely independent party. That's what restructuring is, and that pot of money that the actual value of the business and the value of the assets is made available to creditors and distributed in accordance with the Corporations Act. In theory, there's nothing illegal or undesirable about that particular set of scenarios. The problem becomes were the assets even valued? And very often they're not, they're just simply transferred. B, were the assets valued at an appropriate level? One of the issues that we have, particularly with pre-insolvency people these days, is what instructions were given in respect of obtaining a value. Very often I've got 3 or 4 matters at the moment where the valuer was just instructed to value the particular physical assets of the business that were there, and that was it. And then those were transferred, and that was the value that was left behind for the creditors. There was no attempt to put any value on goodwill, or not that there is a hell of a lot of that in the majority of insolvency entities, but the business went on to continue to contract with exactly the same clients as what it had been contracting with. So there was a value that needed to be attributed to the work that they took on. WIP was never valued. The value of relationships, the value of name in certain circumstances were important. Things like bonds associated with rentals. I had a particular company that had a bond with its landlord and had some value from being in a particular location as to where it was. The value of that bond was somewhere in the order of $40,000, I think, that the company had attributed. for various reasons, the company only had a small number of assets. It was a service company, and the computer equipment and all the rest of it was valued at maybe $20,000, and that's what the sale of the business was. And I came along and looked at it and went, well, hang on, the bond that you've attributed, you've stayed in exactly the same location. You've just signed a lease across into the new entity. You've made arrangements to pay the landlord. That's part of the new lease. I can see it here. And effectively, you've just transferred the bond across into the new entity. I'd like the money for the bond. That's a sale figure. So, the liquidator needs to go through those whole processes and have a look at those particular matters. They're matters that may or may not occur to the pre-insolvency advisor or the outside party that's looking at the matter. One of the particular issues that comes up is obviously there's very little money left in the majority of these circumstances for us to look at this. And we might be looking at retrospective things. I mean, one of the things that we've seen occur regularly over this period of time is that the phoenixing will occur 6 months, 8 months, 10 months before we're appointed. The company will just sit there dormant. The directors will continue to bat away claims by creditors, and then they'll eventually put the thing in liquidation. And so for us, we have to look at the value of the assets, not as they are now, or the business, not as it is now, but what it was 10 months ago, in determining whether phoenixing has occurred. And if we've got no funds to do that, then liquidators may not be willing to pursue those investigations to their fullest extent. And of course, things like books and records, for instance, I've seen, again, something that's occurred probably in the last 5 years or so is that, there'll be that sort of arrangement, and then there'll be a confidentiality clause involved in the sale, or there'll be the sale of the actual books and records, and there'll be an argument by the new purchaser that I'm not entitled to look at those books and records because they're being sold by the old company, and therefore I can't continue on with my investigations, or I'm extremely limited in being able to do so. The other side of things effectively is also the regulator. Look, the reality is that the ASIC isn't staffed or doesn't have the financial capacity to go about and assist liquidators in pursuing those sorts of investigations. And the reality is that there's just not the penalties associated with directors or for directors in terms of having a look at when they are liable for phoenixing. I think there was a quote by the head of ERISA recently who made the comment that it's harder to get a library card in this country than what it is to register at ASIC, register a new company at ASIC. So that's certainly an issue. It's very easy within the current ASIC forms to have your name occur 3 or 4 different times, and to have searches not necessarily catch all the entities in which you're associated with. That's very easy, changing birth dates, just changing slight spellings on names, changing dates of birth, places of birth. They're all things that make it quite easy to be able to do that sort of stuff. So what the government has had a look at is to establish what a specific phoenix offence is, which will be interesting because that requires a definition of activity. And as I mentioned, it's sort of a grey area as to exactly what specifically is phoenixing. If you go down the extent of doing the proper valuation and you miss something, is that an actual phoenixing sort of thing, or is that just an error? It's really a look at what the actual intention is of the director, and very often that's something that's retrospective. In terms of actually tracking these directors, there is something that the government wants to introduce in terms of director identification numbers, which I would be generally supportive of. And directors would have an actual number or be assigned an actual number and would have to quote that number in relation to further entities that they may register at a later date. The other idea is that the director's penalty notice regime, which currently exists and looks at unpaid PAYG and super contributions, would be extended to include unpaid GST. So That's frequently something that we see, with respect to these companies. The ATO is always a liability, and these things are outstanding. Again, whether you get to a DPN notice, there's quite a few entities that we deal with that never actually get to that particular set of circumstances before they're placed in liquidation. So I don't know exactly how much that would impact. The potential for liquidators to be appointed on an off the cab rank basis, same thing as what applies to barristers. I'm not exactly sure that this is going to be of much help. It potentially addresses liquidators that are supportive of this particular endeavour, but the new legislation contains massive changes in how to report a liquidator for breaches of their duties. So why this would particularly be introduced, I'm not quite sure. And then there's potential for the establishment of a government liquidator, but again, that's another department, so I don't know whether that's actually going to come in. So that's the end of our presentation today. As I say, our Insolvency and Reconstruction Division here, we have offices here in Brisbane, Sydney and Canberra, and we have insolvency specialists in each of those particular areas. We also have offices on the Gold Coast, and obviously our Brisbane staff support that particular arrangement. We specialise in turnaround solutions, insolvency, both personal and of a corporate matter, and we're more than welcome to, or more than willing to talk to your clients at any point in time and discuss the matter, and to come in and have a look at the particular issues. I hope this has been beneficial. If there are any questions, by all means, feel free to get in contact with me. But outside of that, have a great afternoon. Thank you very much.